So here we are just a few days since Friday the 13th, and boy, do we have a scary story for you. We're talking all about the tenant from hell. Let's get started. So today I want to talk to you about a tenant who resided in a house originally from an Airbnb long-term rental. Now, in this particular case, the original rental was set for 6 months, but was extended by permission by the landlord beyond that. The rest of the case is an absolute mess. So the parties in today's story are Sasha Jovanovich, the landlord, and his tenant, Elizabeth Hirschhorn. Let me set the stage for you. Jovanovich rented out his guest home to Hirschhorn at $105 a night on Airbnb. The original rental was for 6 months, and Hirschhorn paid slightly over $20,000 for the opportunity to stay in this place in the Brentwood community in California. Now, where Jovanovich thought it would be a simple transaction to have someone stay in his guest house over an extended period of time and collect revenue from that, turned out slightly differently when he established through this agreement a residency for this tenant. He never intended to be a landlord. There's a difference between a short-term stay and a residential stay. Generally speaking, an Airbnb doesn't amount to an establishment of residency, but in this case, because it exceeded 6 months, it's very easy for someone to establish that they are now residents in this unit. They begin to receive mail there. They might, for example, register a vehicle based on that location. They may even register to vote based on the precinct where they are currently residing. All of these things are proof of an establishment of residency. In this case, it was pretty cut and dry. This tenant was a resident, and Mr. Jovanovich was her landlord. He was no longer just engaging in short-term vacation rentals. Now he was subject to landlord-tenant law. And unfortunately, people who dabble in the market and don't know where the lines are blurred or where they are definitively crossed can get into a venture they never intended to. It's clear that was the case with Mr. Jovanovich. And what makes it clear is that he handled the entire situation poorly. Yes, it is true that Hirschhorn stopped paying rent, but many of the causes here were Jovanovich's fault. If your tenant understands the law better than you do, you're likely to be taken advantage of. Landlords, if you're learning something new from this video, I invite you to subscribe to our channel if you haven't done that already. In either case, give us a thumbs up to show just how much you like our content. And any comments or questions, please leave those for me below. I'll personally review them and respond to them as soon as I can. So the tenant in this case either knew beforehand or eventually found out that the unit she was renting was not properly permitted. The city of Los Angeles has a special provision in its code that requires that any rental for occupancy of a tenant must first be permitted by the city of Los Angeles. Because this permit was never in place, technically speaking, the landlord was leasing property illegally. Additionally, the tenant finds out that one of the showers had repairs done on it, again, without a permit, making the unit itself impermissible on the rental market. So her claim then is, why am I paying rent for a unit that isn't even allowed to be rented out? This argument ended up proving valid, so that when a Los Angeles housing inspector reviewed the facts of the case, they determined that the eviction lawsuit filed by Jovanovich against Hirschhorn was no longer valid on the basis that Jovanovich's property was not permitted for occupancy and that the repairs on the bathroom had not been properly permitted. These two things required correction before Jovanovich could evict. Now, the problem that's arisen since this determination by the housing inspector is that although Jovanovic has made attempts to enter, he has been prevented. And so now Jovanovic has had to file a separate lawsuit against Hirschhorn because she is denying him access so that he could essentially remedy the problems that prevent him from moving forward with an eviction. In the state of Texas, we know that a landlord is not permitted on the premises if that entrance is not at a reasonable time for a reasonable purpose and in a peaceful manner. And it doesn't matter that the tenant is the one who breaks the peace. Once the peace is broken, the landlord simply cannot come onto the property and do anything. In the state of Texas, that would be sufficient for cause to seek eviction. Under California law, if a landlord has zero cause for removing a tenant, then the landlord can be assessed moving fees to compensate the tenant for, again, being required to vacate property without cause. If the tenant has otherwise not violated the lease, you can't ask them to leave. Holdover is not enough as long as the tenant is otherwise in compliance. I'm not licensed in the state of California, and I don't know if non-payment of subsequent rent constitutes cause. Kind of sounds like it would, but the problem again with Jovanovic's case is the fact that he wasn't permitted to lease the unit in the first place. So I don't know if you get past that barrier before you're able to proceed with your eviction. Now that the tenant has prevented Jovanovic from entering in, since the landlord simply cannot enter to rectify these issues, it appears that maybe now he has cause to begin the process anew. For landlords who are thinking about leasing residential property in this way, either as an Airbnb or as a short-term rental, you have to consider the risks of following the law and what your tenant may say against you whenever you have failed to follow the law. There are certain rights and remedies that are available to tenants, which include termination of a lease and sometimes include civil penalties, attorney fees, court costs, and interest that can be assessed against you for failing to follow what the law requires. Jovanovic's attorney, Sebastian Rucci, says the following: if she's right, referring to Hirschhorn, the tenant, you can rent an Airbnb for 2 days and refuse to leave on the third unless the landlord pays you to leave. Because Jovanovic had to seek a second lawsuit against the tenant for non-payment and for refusal to allow him to enter the unit, to complete repairs, and to make sure that he is permitted to operate as a landlord, now Hirschhorn has filed a counterclaim against him. She claims that she's being harassed and intimidated by Mr. Jovanovic in the following ways: doing unnecessary construction, placing rotting bags of trash outside her door, shutting off her hot water, and unlawfully entering the unit. Whenever a landlord attempts to remedy a situation without first seeking legal counsel, whether you're in California or in Texas or some other state, you need to know the rules of the game. If you go and take things in your own hands and attempt first to rent out property without knowing the consequences of certain time frames and certain requirements, you run the risk of getting a tenant from hell. Additionally, when you take it into your own hands to remedy a situation by doing things that might make it uncomfortable for your tenant, you are actually potentially creating a new cause of action that will be assessed against you, and that some of the tenant protections that exist in the law can be raised in some subsequent filing, the way you see it in the Jovanovic matter, and now affirmative claims for intimidation and retaliation have been raised and essentially could continue to hurt any prospect of eviction on Jovanovic's part for doing things allegedly that amount to intimidation or harassment. These are things that should be avoided, and that if perhaps he had sought counsel before attempting any of these alleged incidences, he might find himself with a different footing. I'm not saying in any way that Hirschhorn, the tenant, has done everything correctly. I'm not saying she's done anything correctly. I don't know that she didn't plan all of this from the start. Unfortunately, when both sides are walking around with unclean hands, it doesn't make for good litigation. It makes for long, costly, and painful litigation. Do you have experience with a tenant that has just been a huge problem from the start? I've got a video right here with similar cases of all sorts of ways that tenants sometimes scam their landlords. If you haven't watched that video, I invite you to watch it along with all the other content on this channel. And until next time, landlords, happy leasing.